Well, on to some very important news. In fact, on 12th of December is when this is going to play out. Chief Justice of India Sanjiv Khanna has set up a 3-judge bench to decide on the contentious Places of Worship Act 1991. A 3-judge bench headed by CJI, also comprising of Justice Sanjay Kumar and KV Vishwanathan, will be hearing a batch of petition challenging the constitutional validity of the 1991 statute on 12th of December. The batch of petitions include petitions from both Hindu sides and from the Muslim sides. Well, while the primary argument addresses by the Hindu side states that the act has taken away power from the court and religious sects to restore their places of worship, the Muslim side, on the other hand, says that they have maintained that the present challenge seeks to indirectly target places of worship which are presently of Muslim character. The central government is yet to clear its stand on the issue of constitutional validity of the said act. My colleague Kabir Naqvi spoke to Supreme Court advocate Rajiv Nanda. Take a listen.
It certainly is going to be a very tough task for the Supreme Court, needless to say. I mean, given the news pieces that we're picking up these days and what happened with the Babri Masjid and the Ram Janmabhoomi in terms of exemption, the mandate, the sections of the act, it is going to be reintroduced and, retouched upon. Do you really think this is going to be an easy path for the Supreme Court?
Well, it is certainly not going to be an easy task for the Supreme Court, because this 1991 Act, Places of Worship Act 1991, which was brought in July 1991, was brought in keeping in view the secular character of the Constitution of India. The preamble says secular, democratic, socialist Republic of India. So this is picking up the secular character of it. And a date was given, a date had to be given, that which date from onwards the religious structures will be protected. So that date was chosen as 15th of August 1947. Now I have my doubts whether this can be said to be an unconstitutional act, though the claim of the Hindu side is that this takes away their religious rights under 25 Article 25, 26 and all those, to reclaim the invaded and encroached places of worship of Hindus, which were taken away before the 1947 Act. So this virtually invades their right. But there is nothing unconstitutional as such which will require the court to interfere. Here the thing is that this is the domain of the executive, the legislative at the moment. They have to take the call, and because the central government has not yet filed their stand in the Supreme Court on this act. So, and presently the BJP is in the majority. They can, if they so wish to, bring in a new act, repealing this act, and everything will be all right. But I have my doubts that the Supreme Court will be in a position to declare it unconstitutional. I mean, to get it unconstitutional, it has to violate any of the articles of the Constitution. I don't think that it is violating any of the articles. It is the will which has to be brought in by the legislator.